This courtroom hearing centers on Quinton Sells and a critical question of competency before trial. The court is reviewing multiple reports after Mr. Sells was previously found not competent and sent for competency restoration treatment. Judges must carefully examine medical evaluations, treatment recommendations, and whether a defendant currently understands the legal process they are facing. In this hearing, several professionals provide information regarding Mr. Sells' competency status and the need for continued evaluation. As the court reviews these findings, the next steps will depend on the evidence and recommendations presented inside the courtroom.
Good morning. How are you?
Oh, no, right.
Good morning. Are you Kenneth Harrison? And will your client waive the formal reading of the motion?
He does.
Mr. Harrison, in cause number 24 DCCR 0544, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 19th of 2024 for the first-degree felony offense of aggravated robbery, and that was a 10-year deferred probation. Is that correct?
No.
The motion alleges that you violated your probation Count 1 alleges that you failed to report as directed on or about March 31st of 2026. Is that true or not true?
True.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample June 24th, August 27th, October 30th of 2025, and March 9th of 2026 that tested positive for tetrahydrocannabinol. And is that true or not true?
Your Honor, I can abandon 4, 5, and 6. We can skip to 7.
Count 7, let's see, state abandons 4, 5, and 6. Count 7 alleges that you committed the new offense of failure to identify a fugitive or give false information on July 13th of 2025. And is that true or not true?
True.
Count 8 alleges that you associated with a convicted felon and disreputable person on July 13th of 2025, and that you were stopped by the Port Arthur Police Department with Gerodrick Randall, a convicted felon, and that he fled on foot while possessing a weapon. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, 7, and 8 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
Well, give me just a second.
Your question would be the underlying offense, Your Honor.
I'm just going to go back and look at the PSI real quick.
He was one of 4 individuals that were breaking into cars. When they got caught, one of them fired a shot at the person who confronted them while they were breaking into cars at a parking lot. I put everyone on probation. They've all come back, Judge.
I guess my concern is that there was obviously a gun and a shot in the underlying offense.
I do recall Mr. Harrison not being the shooter. I think we were able to figure out who.
That he's in another gun? I mean, another car with somebody
Yes.
with another gun?
And Mr. Randall's been revoked and sentenced to 8 years. He had a drug case, a new felony. So which is why his was a little bit more.
Look at something else. Do you happen to have the PC for that? The new,
For his new event,
Big Daddy.
Yeah,
I do, Judge.
thank you.
I also have the report from Mr. Randall's charges from the same stop. If you're asking as far as where going was.
Yeah, that's
Mr.
what-
Randall's lap as he ran from the vehicle and fell out as he ran.
Obviously, I'm just having some concern.
I understand her.
Yeah, obviously, we're all over. Can't tell you how over we are with guns. And the fact that this is the second out past curfew with in a car doing whatever you're doing that you shouldn't be doing with another gun.
I will state, Judge, it was at about 6 o'clock in the evening. I don't think it was past.
Oh, it was?
No,
I'm sorry, I thought I
it
read
was-
something
it's
about curfew. That
Not,
was,
not this one, Your Honor.
okay, thank you, Mr. Nick. I don't guess it really matters what time it is. And the other three that have already been revoked.
Mr. Randall received 8 because he was in possession of a firearm.
So was he one of the original
I think so, Judge. I do know that.
co-defendants under the underlying case as
I
well?
believe that's why he wasn't supposed to be hanging out with him. And then,
That would probably.
there's
be- It'll have in here. Who?
yes, Your Honor, he's one of the original.
Okay,
One
I'm
of
not
the
gonna,
co-defendants.
yeah. I'm not gonna accept 5. Not if you're already on probation with the same person for aggravated robbery with 3 guns in that car, another gun in this car. If he got 8, then I would consider that, but at this point,
We'll discuss it. Your Honor.
I'm over all of this gun stuff, so I'm gonna, I'll keep, I guess, the paperwork for now. If y'all come up with an agreement,
Yes.
otherwise it's a motion to revoke. I don't have to accept any agreements. It can just be up to me and we can have a hearing if we have to. But I'll just keep it for now. I can make an adjustment if you guys come up with something different.
Okay.
All right.
Thank you.
Go back. Good morning. Are you Quentin Sells?
Yeah.
And we've got cause numbers 25 DCCR 1473, 1474, and 1475. Mr. Sells is charged in each of those cases with assault on peace officer. I'm going to take judicial notice of the court's file in all 3 of those cases. Mr. Sells was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I have received the report from them. In that, it includes a trial competency evaluation report dated May 4th of 2026. The opinion in that evaluation from a Dr. Emery is that Mr. Sells is currently not competent to stand trial and that further treatment would be necessary for competency restoration. In addition to that, I'll also have the forensic psychiatry report, which is dated May 5th of 2026 also. It is from a Dr. Shahani, also has that same opinion that Mr. Sells is still not competent to stand trial. Then I also have a physician certificate of medical examination for mental illness. This is from Dr. Shahani, dated May 5th of 2026. It makes the finding as well that Mr. Sells is not competent. It does state that he does not meet the criteria for inpatient, but would meet the criteria for an outpatient commitment for competency restoration, that the nature of his mental illness is severe and persistent, and that without treatment, he would continue to decompose and or deteriorate and not achieve competency. I also have a physician certificate of medical examination from a Dr. Polizzato. This is dated, well, let's see, May 13th of 2026. It has the same finding that Mr. Sells is still not competent to stand trial, but that outpatient commitment is what he meets the criteria for, and that he would require further treatment for competency restoration. Is there any other evidence with regard to competency? Mr. Rojas?
No, Your Honor.
Mr. Coleman?
No, Judge.
So obviously, you both know, we all know that we do not have an outpatient competency restoration program here in Jefferson County. And so I will have no choice but to order further inpatient treatment at the appropriate facility. Hold on just a second. And so I am going to find at this time that Mr. Sells is still not competent to stand trial, that he is mentally ill, and that because of that, it is severe and persistent, and that if not treated, he would experience deterioration and the inability to function independently, and that treatment would be necessary. I'm going to order treatment at this point in an inpatient facility for a period of not to exceed 1 year under the civil commitment, and that we will await a report at that time. If something occurs before then where competency is restored, then they will let us know immediately.
Judge, I would like to say, I'm sorry to interrupt the court, but given the nature of these charges, the next time we are in court, if we are in a similar situation, the state will reconsider a way forward
Okay.
in these cases.
Okay, perfect. I know there's some civil locally.
At this point, the court is focused on the legal issue of competency restoration. The judge is not deciding guilt or innocence in this moment, but instead reviewing whether Mr. Sells is currently able to proceed through the trial process. The reports presented to the court describe continued concerns about competency and recommend further treatment. With the court considering these professional evaluations, the key question becomes, how should the justice system move forward when competency remains unresolved? The judge must balance the information provided by medical professionals with the legal requirements of the case before making the next decision. Let's return to the hearing as the court explains the next step.
Right, I think the doctors still think they think you need a little more treatment so that you understand all of your legal proceedings, okay? All right, you can go back with the bailiff. Mr. Rojas will visit with you. Thank you. Smith, I don't think there's any expectation of restoration. I think there's more of an issue of. So anyway, take a look at it.
Yes, Judge. I think there's another way we can go
Okay,
with this.
I agree.
Next time.
Johnny Segita or Segeda?
I think it's a good.
Johnny Segita. Okay. Johnny, what? Good morning. Are you Johnny Segeda Jr.?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
Here you go, Your Honor.
Mr. Sagita, in cause number 26, DCCR 0795, you're charged with the second-degree felony offense of burglary of a habitation from April 21st of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rowe?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 10 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 10 years, I can give you 10, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing. But as long as I stay within that range, you are giving up your right to appeal. Do you understand? I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first is if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them.
Yes, ma'am.
If we go forward this way, you're waiving that. Is that what you want to do?
Yes, ma'am.
Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, it looks like as part of that agreement, the state is agreeing to dismiss cause number 26, DCCR 0796. Is that your understanding?
Mhm.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sagata is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. And the probation department will do a pre-sentence report. That'll give me more information about your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Rojas. He'll present it to me on your behalf when we come back. Okay, you can go back with the bailiff. What about Byron Morris? I have it. Let's do Byron Morris.
Byron Morris. Byron.
Well, maybe some stuff. Hey. It's all right. Good morning, sir. Are you Byron Jamal Morris?
Yes, it will.
And Mr. Rojas, will your client waive the formal reading of the motion?
It will, Your Honor.
Mr. Morris, in cause number 15-21651, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 21st of 2016 for the second-degree felony offense of burglary of a habitation, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of public intoxication November 6th of 2025. And is that true or not true?
Not true.
Count 2 alleges that you failed to report to the Jefferson County Probation Department for your administrative hearing December 18th of 2025. Is that true or not true?
Yes, Your Honor. True. True.
Count 3 alleges that you failed to comply with the curfew in that you were outside of your approved residence at approximately 11:59 p.m. November 6th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you admitted to using alcohol on September 15th of 2025. Is that true or not true?
Not true.
Count 5 alleges that you're behind in your court assessed fees as of January 14th, 2026 in the amount of $7,711. And is that true or not true?
True, Your Honor.
Did you enter your pleas of true to counts 2, 3, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 5 years in prison. Is that your understanding?
Yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Morris is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'm going to reset your case for sentencing so that the probation department can do an updated report. Also, so that the state can bring any witnesses with regard to counts 1 and 4. And I'm assuming if there's an officer, even with the public intoxication, it wouldn't be longer than a regular day. We can add it to the end. All right, so we'll set this so that we have time for a couple of witnesses just on a regular Tuesday docket. Anything that you think is important for me to know, make sure you get that to Mr. Rojas, and he'll present it to me on your behalf when you come back.
Yes, ma'am.
Okay, you go back with the bailiff.
Thank you, Your Honor. Thank you.
Thank you. Mr. Parker, Dontrell Robertson, you're asking for some more time on that?
Yeah, we're just gonna try to work the case out. It was set for a bond hearing.
Okay,
So we're gonna pass on a bond hearing. We're gonna try to get the case worked out.
today?
I
You just need
don't have
more
all the
time.
information yet.
Okay,
Get the
so
new case.
we'll reset Dontrell Robertson, just a normal reset. The about Brent Smith.
Well, that should be papers.
Okay, I don't have them yet.
Oh, really?
Do you have papers for Brent Smith? Okay, thanks. We can go ahead and get Mr. Smith. I'll take care of it next. Brent Smith. You need to fingerprint him? Yes. Okay. Mr. Smith, if you'll step in front of the clerk first real quick so she can swear you in and take this thumbprint.
I wrote drug course, but it's supposed to be substance abuse on the ISF.
Oh, I don't see it yet. It's supposed to be ISF substance.
Yeah, I just put drug.
Oh, okay.
I put ISF drug.
Oh,
I mean,
I figured you knew what he was talking.
I just thought of that. Looked like it. Mayor.
good morning, sir.
Hello.
Are you Brent Smith?
That's correct. Yes,
And will your client waive the formal reading of the indictment?
Here we go, Your Honor.
Mr. Smith, in cause number 26 DCCR 0128, you're charged with the second-degree felony offense of burglary of a habitation from December 20th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them, but the date's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation. there would be a $500 fine, and you would be required to enter and successfully complete the substance abuse track of the ISF program. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number
No
one.
objection.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case. We'll make sure that we have everything in place, in addition to an ISF that you need in order to be successful. And then we'll come back for sentencing at a later date. All right, you can go back with the bailiff. Are you Victoria Bailey?
Yes, ma'am. Good morning.
And Ms. Bailey was previously here in court in cause number 25 DCCR 0278, entered a plea of guilty to the third-degree felony offense of assault on a hospital personnel. And I've received that pre-sentence report. Have you both had an opportunity to review the report?
I have, Your Honor.
Yes, Judge.
Are there any additions or corrections?
None more, Judge.
Not from the state.
All right, Ms. Bailey, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include being on the specialized mental health caseload. That'll make sure you have anything you need in order to be successful. So you can get your drug treatment, mental health treatment. And it's important that you follow through with everything that they recommend. Even if you don't think it's necessary, it's going to be court ordered that you go through whatever program probation says you need to, okay?
Yes, ma'am.
This is a great opportunity because you do not have a felony conviction on your record.
Okay.
And at the end of the probation, if you're successful, the case will be dismissed and you'll never have a felony conviction. So it's a great opportunity.
Yes, ma'am.
The other side of that opportunity, though, is that if you violate any condition of probation, you can be brought back into court and you can be found guilty and sent to the prison for between 2 years and up to 10 years. Do you
Yes.
understand?
Yes.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. It looks like I will be signing also a dismissal in clause number 25 DCCR 0170 as part of that agreement. All right, good luck to you, ma'am.
Thank you. Thank you so much.
So, Mark Hebert's the one we're just going through the motions. Mark Hebert.
Mark, you good?
Good morning. Are you Mark Anthony Hebert?
Yes, ma'am.
Mr. Hebert, best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You can put your hand down. Mr. Parker, will your client waive the formal reading of the motion?
Your Honor.
Mr. Hebert, in clause number 25 DCCR 0455, I have a first amended motion to revoke your community supervision. It shows that you were placed on probation September 15th of 2025 for the third-degree felony offense of driving while intoxicated, third or more. And that was a 5-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count one alleges that you failed to report as directed to the probation department January 13th of 2026 and December 30th of 2025. And is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count two alleges that you failed to report to the counselor as directed on January 12th of 2026 and December 16th of 2025. And is that true or not true?
True.
Count three alleges that you failed to report to your administrative hearing that was held on February 2nd of 2026. And is that true or not true?
True.
Count 4 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
I mean, you look like
He's,
your
he's self-employed and he's had a business for a while. I think business was slow. Part of the great hesitation is he's had some serious health issues. That's why the bond, that's why he's hesitant about answering.
Okay,
Not true or true.
so you don't have to say true just because you're here. So is it true or not true that you failed to work faithfully at suitable employment and provide verification of that?
Not sure.
Okay. Count 5 alleges that you failed to submit to alcohol or drug screening January 29th, January 23rd, January 21st, January 13th, and January 9th of 2026. And is that true or not true?
Yes, ma'am, true.
You did all these dates backwards
I
on
know.
this one. Count 6 alleges that you failed to comply with the program guidelines and rules of JCDI program. Is that true or not true?
True.
Count 7 alleges that you are behind in your court assessed fees as of February 2nd, 2026 in the amount of $168. Is that true or not true?
Pretty sure I've paid up on that.
Okay, be not true on 7. Count 8 alleges that you provided a urine sample May 11th of 2025 and April 13th of 2026 that tested positive for marijuana. Is that true or not true?
True.
Count 9 alleges that you provided a urine sample May 11th of 2025 that also tested positive for methamphetamines. Is that true or not true?
True.
And count 10 alleges that you provided a urine sample also May 11th and it tested positive for alcohol. Is that true or not true?
True.
All right, did you enter your pleas of true to counts 1, 2, 3, 5, 6, 8, 9, and 10 freely and voluntarily?
Yes.
The ones that you pled true to, did you plead to those freely and voluntarily?
Yes, ma'am.
And did you plead true to those because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, 3, 5, 6, 8, 9, and 10 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing. We will have a sentencing hearing. I'll get the probation department to do an updated report. Ms. Malfino, if you have any, I wouldn't imagine whatever you would have would take very long. If you wanted to have any issues with regard to 4 and 7, you can bring witness and we will get your case taken care of at that sentencing hearing. Anything that you think is important for me to know on your sentencing, make sure you get that to Mr. Parker. He'll present it to me on your behalf when we come back. And
Sure.
for probation, this is unagreed. All right, you can go back with the bailiff. Who's that right there?
That.
Oh,
That's it.
what about Donald DeRusso?
Making the paperwork. We've done it. It was all that. That's Jewish. It's like.
Oh,
So I said, you're cousin, because we're not, I said, if you're rich, if you're rich, it's that, do you think you're funny? He said, yeah, he's my favorite. So, yeah, I guess y'all don't have it. Okay. I'm just-
Yeah. So much, you know, and
are you ready for them to bring Donald DeRusso?
right.
Donald DeRusso? Donald DeRusso.
I call him Duraso.
Duriso.
I don't know which right. He answered. And again, she's already emailed the.
Thank you. Let's see, and are we going on count one only?
Yes.
That's fine, Judge. His priors make him habitual by law, but he didn't receive even half the time he is on this case on those.
All right, so are you Donald DeRusso? And will the client waive the formal reading of the indictment?
I will, Your Honor.
Mr. DeRusso, in cause number 26 DCCR 0758, you're charged with the state's going to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon, and that's from April 9th of 2026. And how do you plead to that charge?
Yes,
Are you pleading guilty freely and voluntarily?
yes,
And are you pleading guilty because you did what they've charged you with?
yes,
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
yes,
Do you fully understand them?
yes,
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
yes,
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
yes,
State tenders number 1,
No objection?
it's admitted. Is there any evidence that Mr. DeRusso is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Oh, wait, and I am making an affirmative finding of a deadly weapon. All right, you can go back to the bailiff. Goodness gracious. Need a recording of myself. Mr. Lewis, you've got Avriona Dorsey.
yes, ma'am.
Good morning. Are you Avriona Dorsey?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, yeah.
Ms. Dorsey, in cause number 26 DCCR 0756, you're charged with a first-degree felony. You guys marked off second, but is it a first?
It is a first, Judge,
With y'all's permission, can I change that
Yes, ma'am.
admonishment?
because it's burglary with
With intent.
It's being aggravated assault.
So you're charged, Ms. Dorsey, with a first-degree felony offense of burglary of a habitation with the intent to commit another felony, aggravated assault. And that's from April 11th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement that you've reached is for a 10-year deferred probation fine.
We didn't really discuss fine, Judge.
Typically, there's going to be a fine of $500. I'll look at that at sentencing. Also, part of your agreement, it looks like, is that you're going to enter and successfully complete the cognitive track of the ISF program. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one.
No objection to it.
It's admitted. Is there any evidence that Ms. Dorsey is not competent?
No.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for sentencing.
Okay.
Right? You can go back with the bailiff.
Judge, I think we've agreed if it's the court will accept 8 on Mr. Harrison, we can
Yeah.
call him back up.
All right, Kenneth Harrison, thank y'all.
Kenneth Harrison.
And so what did I put on Harrison? Did we go through the whole motion before I stopped and started looking on it? Let me find it. Oh, yeah, we already went through. He pled true to 1, 2, 3, 7, 8. Okay, state abandoned. Okay, we're back on the record with Mr. Kenneth Harrison and 24 DCCR 0544. Mr. Harrison had already entered pleas of true to counts 1, 2, 3, 7, and 8. And you guys have visited, I guess, about my unwillingness to accept the plea agreement, and if you come up with some other agreement.
Yes, sure, we have
And what is that?
for 8 years.
And Mr. Harrison, is that your understanding, and is that your agreement?
No.
And so with everyone's permission, can I make that modification on the agreed punishment
Your Honor, he said
recommendation?
no.
You said no?
Yeah.
Oh, I thought he said yes.
I said, yes, ma'am.
He said yes.
I heard it wrong.
Sorry about that. It's scary.
That's okay. So can I make that modification on this document?
Yes, ma'am.
Okay. So I have here, Mr. Harrison, on the tablet, some documents that have your signature on them. I've made that change to show that the agreement is for 8 years instead of 5. Before you went over and signed these, did you go over them with Mr. Lewis? Do you fully understand all the documents you signed? And do you understand, if I follow this agreement, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Harrison is not competent?
No.
All right, sir, I'm going to find that you entered your plea of true to counts 1, 2, 3, 7, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. I am making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or how long that lasts, you can talk with Mr. Lewis. So, Mr. Harrison, in my opinion, you're getting a great deal today. You could have gone to prison today for anywhere between 5 years and up to the rest of your life. And I know you've probably been hearing out of the jail what's been going on with the cases where people have guns and are continuing to use them and possess them. So take advantage of the time that you have, do something better with your life. And when you get out, don't possess a gun. Don't be around anybody that's possessing a gun, because if you are and you're here in Jefferson County, it's going to be a whole lot worse than today. Do you understand?
Yes, ma'am.
All right. Good luck to you. You can go back with the bailiff. You'll get credit for any time you've been in custody. Let's see. What about Jermaine Reddo?
Yes, that one, Judge. Meaning fill up the talks like that.
Do we need them out?
I don't.
Judge, what we did, this is the one, he had new charges that were filed. It was a felon in possession of a firearm and the things that you were concerned about. I checked with our intake division. They found they refused those cases based on, complaining witness,
Okay,
found them to be unreliable.
okay.
So what I would propose to do would be, to just go on the technical violation, which would be, well, it was 2:09 PM. Outside of his residence, he was arrested for this and it was, charges were not filed. So I can either dismiss the motion or
There
we can
any
give him a
other-
jail sanction for the time that he's been on.
I mean, obviously, should that be AM? Because being somewhere else at 2:09 PM is not a
Yeah,
violation. I mean, if everything was.
It was AM. That was just a typo in the MTRP, but that's the only allegation that we would probably move forward on.
Let's get Mr. Redo, please. I mean, you can file a motion to dismiss it and I'll sign it, but I want to talk to him real quick before I sign that. I created a new document, but I'm not doing anything with it. There's really nothing to, this is his second. How did the last one get dismissed? Well, third, is that the? So. On these new offenses, the possession of a firearm allegation, is that something that only that uncooperating witness could prove up, or is that something that law enforcement?
There was a
did?
question about whose weapon it was.
Because this is the second MTRP that has to do with,
Well, the first one was dismissed because the only violation, allegation was that he possessed a firearm and fell in possession of a firearm and he had been on deferred, so he wasn't.
right. And, but still shouldn't be possessing a firearm while you're on probation, regardless of that. So, Mr. Redo, probably what's going to happen today, based on the information that I've received from the district attorney's office, is that that motion to revoke your probation is going to be dismissed. This is the second time that you're kind of getting away with doing something that you probably shouldn't. I want you to understand at this point, I'm going to order that you are on 0 tolerance on your probation, that you will be on the high medium caseload and required to do everything that you're supposed to be doing. If you are caught with a firearm, if you're around anyone with a firearm, I don't care who it belongs to, ownership, if you're around it, it is going to be a violation of your probation. I'm ordering a condition of your probation is that you are not allowed to be around or in possession of a firearm in any way, not in the same house as one, not in the same car as one, period, none. So there won't be any question if there's an issue that keeps popping up here with regard to firearms, that if you're around one, it won't matter whose it was or whose it belongs to, it's going to be a violation. And it's not going to get dismissed. You're going to end up going to prison. Do you understand? You're on a very serious probation, and I have some concerns about what's going on. But you're back on that probation. You still have the same opportunity to be successful. It's going to be up to you to quit doing whatever it is that's going on. Okay. If you have an issue with whoever it is that you're dating or married, then you need to get away from that, because that's going to end up getting you into trouble. Right. Okay. You can go back with the bailiff. Evelyn Reyes. What?
And the rest are being dismissed.
Are these the three she's playing on?
Yes.
Okay, thank you. That needs to be.
Oh.
Good morning, ma'am. Are you Angela Reyes?
Yes.
And will your client waive the formal reading of the indictment in each case?
She does, she does.
Ms. Reyes, you are Angela Reyes, correct?
Yes, ma'am.
And Ms. Reyes, in cause number 26, DCCR 0265, you're charged with the third-degree felony offense of obstruction or retaliation from December 22nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 26, DCCR 0787, you're charged with a second-degree felony offense of assault on a peace officer. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then finally, in cause number 26, DCCR 0788, you're charged with a third-degree felony offense of harassment of a public servant. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes.
In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And it looks like the agreements that you've reached in these three cases would be for you to receive 10-year deferred probations in each case. There would be fines in each case of $1,000. You would be ordered to.
Your Honor, I'm sorry. I don't know that it was the intent of the state to have a total of $3,000 fine. I'd be willing to waive the fine on two of those cases and just have.
So a total of $1,000 fine in, let's just put it in 0265.
Yes.
And there would be no fine in 0787 and 0788. Is that your understanding?
Yes, ma'am.
Is it also your understanding that you would submit to a mental health evaluation and follow any and all recommendations and treatment, be on that mental health caseload at the
Yes.
probation department?
Absolutely.
State tenders number 1 in each case.
No objection, Judge.
It's admitted in each case. Is there any evidence that Ms. Reyes is not competent?
No objection.
All right, ma'am. In each of these cases,
Today's courtroom session made one thing crystal clear. Every second chance comes with a limit. Some defendants were given probation and an opportunity to rebuild their lives. Others faced prison because repeated violations, prior convictions, and dangerous left the court with fewer options. But the strongest message came from the judge herself, especially when firearms and repeated probation violations entered the picture. The court wasn't just looking at what happened today. It was looking at the pattern, the risk, and whether another opportunity would actually make a difference. Let us know your thoughts in the comments. And if you want more intense courtroom moments and legal breakdowns, make sure to like, subscribe, and stay tuned for the next case.
The court ultimately finds that Quinton Sells remains not competent to stand trial and determines that further treatment is necessary. The judge explains that because there is no outpatient competency restoration program available in Jefferson County, additional inpatient treatment will be ordered at an appropriate facility. The court places Mr. Sells in inpatient treatment for a period not to exceed 1 year under the civil commitment order, while allowing for updates if competency is restored sooner. The judge also instructs him to follow the facility's rules, take his medication, and continue treatment so the legal process can move forward when appropriate. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.